Hill Country Hillside Limited et al. Versus Bass et al. Let's start with appearances for the record, please.
May it please the court, Tom McCall on behalf of the defendants. Collectively, Judge, I will refer to them generally as the GVA parties. With me is Miss Kara O'Shaughnessy. I have two lawyers, I believe, from our office just observing, to Mr. Villarreal and Julio. So.
Good afternoon, Your Honor. Andrew Vickers for the plaintiffs, Hill Country Hillside Limited, River Retreat 1228 LLC, Hill Country Meridian LLC, and Sierra HC LLC, as well as the third-party defendant in this case, Brian Castleman. We'll probably refer to these entities as the Castleman entities or Castleman.
Okay. And it's defendant's motion, so you may proceed.
Thank you, Your Honor. 3 days before the hearing, the plaintiffs non-suited their statutory fraud claim. So that claim is, which was the subject of our motion, is no longer relevant. That has been disposed of. There are two claims that we are not moving for 91A for, Your Honor. One is fraudulent inducement. Those allegations pertain to alleged fraud in inducing the Castleman Group to enter into these limited liability membership agreements. Also, claims of violation of Texas securities law is not, those are not the subject of this motion. What we're complaining about, Judge, is it's undisputed that there are multiple limited liability company agreements governing the relationship between the parties. Our relationship is entirely contractual. There is attached as an exhibit to our answer to the pleadings is a copy of the Carolina Roundup Agreement. That is not attached, of course, to our response to the 91A, but it is referenced in the plaintiff's pleadings. There are, I believe, Judge, 10 separate company agreements. They're very detailed, governing the rights and obligations of the parties. There were 33 pages of contractual provisions, obligations, duties in the Carolina agreement. Plaintiff alleges that all of those agreements are either identical to or substantially identical to the Carolina Roundup Agreement. So, assuming that to be the case, we estimate that we have approximately 330 pages of contractual agreements between the parties. Curiously, the plaintiffs have filed suit alleging torts, not a single breach of contract action. They complain of fraudulent capital calls. In other words, these agreements allow the parties to make capital calls. There's an obligation to pay capital calls. The plaintiff's own pleadings, Your Honor, allege that these entities, the rules governing these entities are controlled by strict obligations. In other words, there's accounting obligations. There's about every kind of obligation you could imagine, duties, corresponding rights. We look at their petition, they allege fraud. You didn't use the capital calls like we think you should have used them. You misrepresented what you were going to use the capital calls for. We don't like your accounting. We think you should have booked certain expenses different ways. There's pictures of a green swimming pool in the petition. There's a picture of a rat. There's complaints about potholes in the parking lots. They're claiming fraud because you didn't use the capital calls to maintain the properties. So we filed a 91A saying that your complaints are contract, not tort. Under the economic loss rule and the independent injury rule, if what you're complaining about, one, are obligations under the contract, and you'll see in our initial motion, Judge, there are many, many references to the contracts throughout the petitions and the agreements, that if you're complaining about the agreement and the duties and breaches and obligations under those agreements, and your complaints relate to solely to the economic loss of the subject of your investment, those claims sound in contract, not tort. What they've done is taken what I would think is garden variety breach of contract claims and turned them into torts. Everything's a fraud. Anything they don't like in the management is a fraud. And I think Judge telling is when they file their response to our 91A on page 5. They state, while the defendant's actions, no doubt, constitute wrongful breaches of contract and fiduciary duties owed to the companies themselves, the plaintiff's claims are specifically and individually attributable or individually actionable because they were fraudulent acts targeting and causing specific injuries to the plaintiffs. So they admit that their claims are breaches of contract. Yet they claim they're also independently actionable as fraud. Now, the independent injury rule and the economic loss rule don't entirely preclude the possibility that you could have a tort. In other words, if our clients got into a fight over the capital call and somebody punched somebody in the nose, that would be an independent tort that would be actionable, but that would violate a duty separate and apart from the contracts themselves. We've looked at the pleadings, Your Honor, and I don't think there is an independent injury alleged in those pleadings separate and apart from what they allege to be and complain about to be violations of obligations arising under the contract. For example, they allege the contracts prohibit commingling of funds. You commingled funds. That's fraud. You name it. Everything basically in the whole operation they complain about, which again should be contract actions, they treat as fraud. I know what they're trying to do, Judge. They're trying to avoid the allegations they allege are entity level injuries. They don't want to bring a derivative action. If, for example, I believe if you look at Mr. Castleman's interest in South Carolina or Carolina Roundup, I think he only owns 2.31%. But he wants to proceed individually And under these claims, which are, if you complain about how the company was operated, if you complain that funds were diverted, that capital calls were improperly used, those claims belong to the company. That issue is not directly before the court right now, and it certainly raises a capacity issue. But we haven't reached that point yet because they've tried to plead it totally in tort. Mr. Castleman has a remedy. He can plead this claim in contract and seek to file and pursue it as a derivative action. Of course, then his interest in recovery would only be proportional to his interest. And I'm sure he doesn't want to advance the expenses for that and can recover, less than the full amount. But it's our position, and I want to touch again on some of the claims here. The agreements allow for fees, management fees. Their pleadings allege that we charged excessive management fees. That's a fraud. We issued capital calls. Yes, we know you loan money to the company, but you issued a capital call and you paid yourself back. If we had known you were going to pay back the funds you had advanced for our expenses, we wouldn't have honored the capital call, so that's fraudulent. We didn't use funds to stabilize the properties. If we can go to, do we have page 34 of the first amended petition, Carol? Here's an example. They talk about one particular property here, which is governed by a separate LLC agreement, the Club of Isle property. One tenant complained of having no air conditioning for weeks, mold, water damage, rotting cabinets, trash, broken security gates. There is a picture, page 33. You can see the little rat. It's a cute rat, but again, it's not a tort. So basically, summing it up, I believe that they allege that we engaged in accounting fraud, capital call fraud, extracting undisclosed fees, inflating construction costs, falsifying key financial documents, collecting insurance proceeds and not completing the repairs, commingling investor funds, transferring company funds to stock ups individually, commingling funds, and that. And those complaints, Your Honor, that the Castleman groups make pertain to, would pertain to all the investors. I think in some of these, I noticed there's a list, I believe, of the number of investors in the plaintiff's first amended petitions in each one. And some of these have as many, I noticed one had as many as 69 different investors. And if we're in the situation where all 69 investors who received a capital call that they didn't like can file independent suits and proceed independently in tort, then of course that's going to overburden the courthouse when you add all these folks together. And so the essence of our complaint is economic loss rule, independent injury rule bars the complaints. There's not been pleadings of any independent violation of any duty existing in law apart from the obligations and duties arising under the contract, and those must be proceeded in tort. And so we've asked the court to dismiss the claims for fraud and fraud by omission. I did submit a case, Your Honor, on there's a distinction between fraud in the inducement and alleged fraud that is made after the contracts have been entered into. Alleged fraud after the contracts have been entered into and the parties already have their duties and obligations do not create fraudulent inducement. Likewise, those have to be pursued in contract. As you'll note on the site here, where it talks about the seller's fraud claims are based on alleged misrepresentations that occurred after the parties signed the agreement. Because these claims concern representations allegedly made after execution of the purchase agreement. These claims are not claims for fraudulent inducement of the contract. These claims do not fall within the exception to the economic loss rule for fraudulent inducement. You'll see, Your Honor, that the Texas Supreme Court in the Formosa plastics case created an exception to the independent injury rule, economic loss rule for fraud in the inducement. And that's why we didn't move for fraud in the inducement on the 91A. Likewise, negligent misrepresentations have not been excluded under the Formosa plastics rule, and those likewise are subject to dismissal for claims for under the economic loss and independent injury rule.
Your Honor, I'm sorry. I just want to make sure I'm not getting filibustered on my time here.
I'm
This case isn't even a 91A case that he's citing to you.
It's fair. Well, Mr. McCall, you used 16 minutes, but
okay, I'm sorry,
think-
Your Honor.
that's okay. You're the last case, so.
No, well, that sums up my complaint under the 91A, Judge. Obviously, they've dismissed one claim. I don't think that's enough. I think the other claims should also be dismissed on those grounds, Your Honor.
Okay, thank you. All right, Mr. Vickers.
Thank you, Your Honor. If you don't mind, I'm going to share my screen as well. So the case, West Loop Hospital case that Mr. McCall just showed you, and all of the cases cited in their motion related to the economic loss rule, are motion for summary judgment cases. They are not Rule 91A cases. As the court knows, the standard for dismissal under Rule 91A is very strict, and it has to be based specifically, if the court can see my screen, in ruling on the Rule 91A motion, except for on the attorney's fees issue, which does require the submission of evidence, a court may not consider evidence and must decide the motion based solely on the pleading of the cause of action, together with any pleading exhibits permitted by Rule 59. Now, the supplemental answer that Mr. McCall cited you to, the contract, that's certainly not in the record. And their motion rely entirely on their extrapolation of what may or may not be in a contract, which, by the way, a company agreement, not we're not suing the company whose company agreement is at issue. We're suing the manager and the managers of those companies who we don't have a contract with. But everything they just tried to put in the record and try to say is based on contract claims is not before the court because it's not in my petition. And so I think the court needs to be very mindful that this is a premature motion and it's some gamesmanship trying to snuff out some claims that we have before we've even gotten past first base to talk about what's in the claims. Now, Your Honor, as we see here, you have to base the motion solely on the pleading of the cause of action. So let's take a look at that. We're talking about count 1, which is our fraudulent inducement, and fraud by omission claim. Counsel admits they are not seeking dismissal of our fraudulent inducement claim. A lot of the references to the contracts that they kind of wave their hands at that are contained in the petition relate to the contract we were induced to enter into as part of our investment. The first part of this count one relates to that. I'm going to try to read as slow as possible to help the court reporter. But as set forth above, the defendants made numerous false representations of fact concerning the finances and books and records of the various projects. By altering the financials to inflate key metrics in the financials presented to plaintiffs and others, the GVA defendants falsely represented that the real estate projects were performing significantly better than they were in actuality. These are pre-investment misrepresentations, all made in order to induce plaintiffs to invest in the projects. We do go through a laundry list of the misrepresentations that were made that induced our investment. Over $10 million worth of investment across a number of properties. Mr. McCall said they don't want to overburden the court with multiple claims. There's at least 8 lawsuits out there against Mr. Salkup and his fraudulent enterprise that are already overburdening the court. And that the day when the fiduciary duty type allegations get made derivatively will be coming. But in this particular case, the direct injury that my client suffered is twofold. The first is these pre-contract misrepresentations, which indisputably are part of a fraudulent inducement claim and are not part of any motion to dismiss. Second, Your Honor, are post-contract misrepresentations. And as the business court recently ruled in Tall v. Vanderhoff, under Texas law, the economic loss rule does not bar recovery for post-contract fraud when that alleged fraud is not derived from a pre-existing obligation covered by the contract. Your Honor, our second set of allegations about the misrepresentations that the Salkup defendants made are about the inducement to enter into, to give more money to these failing companies based on fraudulent misrepresentations made by Salkup and his co-members of the conspiracy. Mr. Castleman and his entities had no obligation to fund these capital calls. And he wouldn't, and he alleges in his petition that he wouldn't have invested, but for the fraudulent misrepresentations, negligent or with actual knowledge of their false intent, to my client about how the capital calls were going to be used. They represented that they were going to be used to get rid of the green swimming pools and the musty air conditioning and stabilizing the properties. They represented that they were going to be used for the types of things that we do point out in the petition itself. But the actual claim, the actual cause of action, Your Honor, relate to the inducement directly to my client to fund capital calls. That's an individual injury that only my client suffered, and he suffered it on the basics of misrepresentations of fact about how the funds would be used. He never would have funded it if he had known the day he funded it was going right out the door into Mr. Salkup's pocket. That's a false misrepresentation to him to induce an obligation that he did not have, and he got stolen from. Secondly, Your Honor, we allege that the fact that the company had made loans and was not taking care of the property as had been represented, and were cooking their books and making the false entries in their accounting. Had my client known that, he wouldn't have funded these capital calls. And that's what he alleges here. The fact is, we are here on a 91A motion. The terms of the contract and what the capital call might be used for, and the other obligations that the defendants owed, that the manager of the company owed to the company, are not at issue in this lawsuit. What's at issue is the direct misrepresentations made to my client individually, both to induce his investment at the outset, which is a fraudulent inducement claim that's going to survive this motion. And for the purposes of this motion, it was to induce over $400,000 worth of capital call investments on false pretenses, both negligent omissions and fraudulent omissions or negligent misrepresentations. Your Honor, it's no doubt that the economic loss rule is a real thing. I think if you ask 9 different justices of the Supreme Court, it means 9 different things. But here we are on a 91A motion where the terms of the contracts are not in front of the court, where we are not in the actual counts, which are the causes of action that the court considers as part of the 91A. There's no reference to the contract or any contract terms. And that's because my client didn't have an obligation to fund any capital calls. He did it because he got lied to. And that's why he acted, and that constitutes an independent basis and an independent injury that he suffered that's outside any contract that's a part of this petition. And at the summary judgment stage, it's going to be outside of that too. But we're not there. You don't have in front of you the language of the contracts, Your Honor. You don't have in front of you any particulars about the 7 different projects and the various different capital call misrepresentations. And so 91A is not an appropriate time to make any rulings of dismissals on these fraud claims. Your Honor, we conferred beforehand, and Mr. McCall and I both suggested that we would leave the issue of attorney's fees for a later date, or perhaps do it by submission. I do have about 6,360 in fees that I was going to ask for and having to respond to this premature and frivolous motion on the economic loss rule, but I'm happy to reserve that for either evidence later or by submission.
Okay, well, why don't we give the court some time to decide the motion before we worry about what comes next?
Absolutely.
Your Honor, may I just briefly, very
Yes,
briefly
you
respond?
may. Mr. Vickers, will you bring down the screen share? Thank you.
Judge, when Mr. Vickers says that the contracts are not before the court, I refer the court to Mr. Vickers' own pleadings. Starting on, he outlines each of the entities he invested in. And he recites, beginning on page 13, several of the contractual provisions. Paragraph 31, each of the applicable contracts for the investments appointed either GVA Invesco or Pro as manager and imposed strict obligations and duties. Paragraph 10.1.b requires us to maintain accurate books and records. It goes on, it's throughout. And I want to point out, Judge, we made an effort to go through and find every reference to a contractual agreement in our first amended motion. And I'll looking at page 3 of our first amended motion. Page
Your Honor, I'm going to object. There's a contract that on the screen that's not a part of my pleading.
Well, yeah, it's, if we can go through, Judge, what we've outlined for the court in our motion, we have gone through and identified every reference to the agreements in the petition themselves. And I think when you're looking at the economic loss rule and independent injury rule, what's important is to look at the thrust of the complaints. And I think this statement right here, paragraph 22, this is on page 3. The contracts that form the basis of the causes of action in this lawsuit contain form selection clauses maintaining exclusive venue in Travis County. The important part of that is underlined, because when the contracts themselves form the basis of the cause of action, and they have judicially admitted that these contracts that they've all identified and spent a lot of time complaining about in their pleadings form the basis of the cause of action, and the universe of the obligations and duties arising from those contracts are what's being complained about. And we're taking, again, garden variety breach of contract claims and trying to turn them into, dress them up like a tort. And that's not permissible under the economic loss rule and independent injury rule. So for those reasons, Judge, we would request that the court grant the 91A. Likewise, Mr. Vickers and I have talked. I am the agreement that if the court is inclined to award fees one way or the other, that we have those possible heard at a later date. I know Mr. Vickers uploaded some invoices today, and so did we, but obviously we don't have enough time to address that in this hearing, Judge, so we'll leave that to the court on how you want to handle that.
Okay.
Your Honor, if I may real briefly respond.
Okay.
Get the allegations in the complaint that he's referring to that are in the factual background of the complaint relate to a fraudulent inducement claim that we all agree is not part of the motion to dismiss. We do have a claim for fraudulent inducement that you promised us you were going to follow all of these duties in order to induce our investment. And we believed you, stupidly, perhaps, but we believed you. And so we invested over $10 million. That's a fraudulent inducement claim. That's not even at issue here. That's everything he's referring to is in reference to that. If you read the actual causes of action, which again, under the Davis case I showed you, is all that the court looks at in a 91A motion. Our fraud claim relates to the capital call misrepresentations. And there is nothing that they cite to or that they refer to that relates to a breach of contract allegation in our petition related to that. It's a pure fraud claim for misrepresentations directed directly at my client. The other references to the contracts and everything relate to an inducement claim that's not before the court. Thank you, Your Honor.
Mr. McCall, normally I would give the movement the final say. I don't know if you have anything else to add.
Only a comment I would have, Your Honor, is, again, I think if you look through the background of the pleadings here, there's many reference to the plaintiffs and other investors. And I think that, these are, again, entity level complaints that should be breach of contract, not tort.
Okay. All right. Well, I think you probably suspected this, but I'm going to take this motion under advisement and give it the time and attention that it deserves. And looks like the motion was filed about 45 days ago, and normally that's the required deadline for the court to rule on them, but I'll get you a ruling as soon as I can. Any questions for the court before I let you go?
No, Your Honor, we appreciate your time.
Thank you.
Okay, thank you. I appreciate your flexibility in joining us a little earlier today than 2 o'clock docket. I have a speaking engagement that's this afternoon, and it's a little bit further than what I thought to get to. So appreciate your cooperation. Seeing nothing else on the docket, you are all excused from the courtroom.
Thank
Your
you.
Honor, would you like us to email proposed orders to you? If we haven't already?
Not yet. It'll just get lost in the inbox. We'll let you know when the decision has been made, and we'll ask for an order at that time.
Thank you.
All right. Thank you.